Hello, my name is Addison Caruso, and I'm an Ohio staff attorney with Fair Shake Environmental Legal Services. This is a know before you sign brief informational video about what you should know before you sign a contract to lease your Pore or storage space for carbon capture and storage. Fair Shake Environmental Legal Services is a nonprofit law firm that represents clients of all income levels on environmental and energy justice matters. We are dedicated to the idea of community and client-centric representation and believe in empowering the communities and individuals we work with. We provide services on both a pro bono and sliding scale basis to individuals and organizations and focus on traditionally underserved clients who are directly affected by environmental harms. We have many wonderful non-attorneys on our staff as well who provide support, resources, and assistance to communities and assist them in building people power. We have a robust internship program as well, where we aim to educate young attorneys and law students to understand how they can best serve underserved communities. As a disclaimer, this presentation is designed for general informational purposes only, and this information contained in this presentation should not be construed to be a legal advice or to signify the formation of a lawyer-client relationship. If you have any follow-up questions or need legal representation, we recommend you consult an attorney. What is pore space? Pore space is the portion of the soil that is empty between the particles of sand and sediment or the space between rocks. Generally, pore space exists naturally or it exists after oil or gas has been extracted from underneath. Generally, when carbon dioxide is injected into the ground, it ends up filling the pore spaces. This region, Eastern Ohio, West Virginia, and Western Pennsylvania, has been identified as having the right stuff, which means we have the right geology to be a good spot to store carbon. This is because much of the area has had a lot of oil and gas extraction, which leaves spaces for carbon to theoretically fill those space that was left behind after the oil and gas was extracted. What is in a contract for pore space? Each contract is different, and you'll need to look at the specific detail to determine what exactly is in your contract. But generally, each contract for pore space will be between the landowner or the surface owner and the company that seeks to pump carbon dioxide underground after sequestering it. Generally, these agreements convey the length of time, which determines how long the lease will be in place and whether it's for a fixed term or not. Also, this might determine during the lease if the landowner can use the property for other purposes or can terminate the lease early. The carbon dioxide storage rights include the exclusive right to store carbon in a reservoir area. This area is often very far, thousands of feet below the surface. Surface rights are the right to use the surface for the carbon capture and storage company to construct and install the equipment, which is the sequestration system, which can include things like an injection well, pumping facility, or any other facility that might be needed. The size of the facility can vary. This can also potentially include the surface rights for a pipeline to transport the carbon dioxide or other transportation means in order to service this carbon sequestration system. Generally, landowners will retain the right to access or use the property for any purpose, as long as it does not interfere with the carbon capture and sequestration or the company's storage rights, and this can be in the form of an easement. Generally, the surface rights are leased as well because you need space for the installation, maintenance, and operation of the pipelines, meters, and other equipment, as well as the transportation of carbon dioxide from its source. Finally, payment is typically included as well, and this payment can be through a lease bonus, an annual rental fee, or a royalty payment based on how much carbon dioxide is sequestered underground. As stated before, each of these vary based on the contract, and you should look at the specific language contained within. Some red flags to watch out for. These are general red flags that you should be on the lookout for in a potential pore space contract. An indemnity clause. An indemnity clause may allow the company to not reimburse you for any damages or leaks from to your property from carbon capture that it causes. You should be on the lookout if there's no indemnity clause, meaning that you might be on the hook for any damages caused. Broad sweeping terms that cover many things and leave ambiguity. One-sided provisions that favor the carbon capture and storage company rather than yourself as a landowner. Low-value offers. High-pressure tactics, such as someone saying you have 10 minutes to decide or I'm walking out the door if you don't agree, or not allowing you to consult an attorney before you sign. a lack of surface protections, meaning that the company could destroy the surface and not have any responsibility for repairing it, and buried terms hidden in the fine print. You should make sure to read the contract in its entirety and consult an attorney or other professional if you have any questions. Before signing, I think the slides went off.
Oh no, I see them on mine.
Yeah, there it is.
Okay, that was weird. All right, go for it.
When talking with a carbon capture and storage company, it is important to negotiate. You can take your time, consider talking to an attorney, and make a decision ultimately that is best for you, your family, and your land. Do not feel pressured into a situation. You must ultimately make the best decision for yourself and take your time if you feel that it is needed. If you have any questions, please get in touch with please call us at our phone number or email us or get in touch with us on any of our social media services. Please feel free to check out our website as well. Thank you very much.